Hello, my name is Anthony Wright. I'm an attorney. I'm the owner of the Wright Law Offices, which serves Henderson and Las Vegas, Nevada. I'm an estate planning attorney, and I hope to meet with you to discuss your estate. In the meantime, please enjoy my content. The question is, why wouldn't you just give your property to your heirs while you're alive, instead of creating an estate plan and leaving it to them in a living trust or in a will, or doing nothing? Well, if you do nothing, your property will have to go through the probate process, which is pretty expensive. Your heirs have to hire a lawyer, go to court, go through all your stuff while they're sad or frustrated. Maybe they're coming in from out of state. There's travel expenses. Very frustrating. So you want to avoid that for your heirs. You could do a will. A will is a little bit better than doing nothing, but still, it would be probated. They'd still have to come in, go through your stuff, and so forth. But at least with a will, they know what your intentions are with the stuff. They know that you have certain things because you list it in your will, and they know who's supposed to get it, so there's some direction there. And it could just be even stuff that probate doesn't really care about, like picture albums. They want this heir to get this picture album and that heir to get this lamp, stuff that's not really valuable but might have sentimental attachment. To avoid probate, you would want a living trust to leave all your stuff to your heirs. You would assign a successor trustee. You're the initial trustee. You assign a successor trustee. That successor trustee takes the place of the judge in probate court, looks over the trust and says, okay, there's these things that this person wanted these people to get. Let's make that happen. Okay. If you have a simple trust and they don't need to hire a lawyer to understand it, they can pretty much administer it. Or even if they do have to hire a lawyer just for a little bit of advice, it won't cost that much. They won't have to open a probate and so forth. Now, why though, if you have a house, why wouldn't you just add your heirs as joint tenants with right of survivorship, for instance? That's a common way to hold property. If you die, then the other joint tenant automatically gets the property, and you can avoid probate that way, right? That's a way to avoid probate, and certainly something you can do if you want. Add co-owners, joint tenants with right of survivorship. Might be a good thing for certain individuals in certain circumstances. But here's a potential issue with that and why you might still want to put your real estate, your house, into a living trust. It's called the step up in basis, and it's a tax thing, of course, right? The only certainties in life are death and taxes, and this is both death and taxes. So if you add your heir as a joint tenant with right of survivorship, and you die, and they get the property, and they decide they want to sell the property, and the property has gone up in value since you bought it originally. Say you bought it at $100,000. You die, and now your heir wants to sell it, and they want to sell it at $300,000. They're going to have to pay capital gains tax on the difference between what you bought it for and what they sold it for, which would be $200,000. They'd have to pay capital gains tax on $200,000 potentially. Okay. You can talk to, if this situation arises and you don't want to pay capital gains tax, you can talk to lawyers about maybe other ways to get around it. But by and large, if you want to avoid that capital gains tax for your heirs and you think your heirs are going to sell the property, you put it in a living trust, listing your heir as a beneficiary. When you die, they then get the house, and if they sell it then at that point at $300,000 and the house is worth $300,000 at that time, they get what's called a step up in basis. Instead of subtracting the $100,000 you bought it for from the $300,000 they sold it for, Your $100,000 that you bought it for is irrelevant. We only look at that point the $300,000 it's valued at when they got it, and the $300,000 they sold it for. Guess what? $300,000 minus $300,000 is 0 capital gain, so 0 taxes potentially. Of course, if they wait a while and the house goes up, say it was $300,000 when you died and it goes up to $320,000, and they sell it at $320,000, maybe there will be a small capital gain of $20,000. Either way, it's still tax advantageous to leave the property in a living trust, than to add them as a co-owner with the right of survivorship. I just wanted to cover that simple concept. It's a little bit hard to grasp and understand, but that is one of the main reasons to put your house into a living trust instead of giving it to your heirs. You certainly also want to avoid probate, so you don't want to leave it in a will or have nothing. So you want a living trust. Hope that was helpful. Look forward to meeting with you at my office, or I will go anywhere in the valley, Las Vegas Valley, within reason and within reasonable hours, to meet you a couple of times, prepare your estate plan, get a mobile notary on board, some witnesses, and for a reasonable price, I can help you with these types of issues. If your estate is a little bit more complex, I know tax experts and I know experts in the field that are even well beyond me. Of course, they'll charge more, but it may be worth it if you have a lot to lose. Hope you enjoyed my content. I look forward to meeting with you.
Please like, share, and subscribe. Thank you and have a great day.